Hi, my name is Ryan Cannonie. I'm an attorney with the Tahlequah office for Worth Law Office, and I posted a video a little while back about, I think it was like a week ago, about State Question 805 and not really pro or against it, but to kind of explain some stuff around it. And we had a comment by someone named LG, had a whole bunch of questions. So I'm going to break this up in a couple videos, otherwise it's like a 20-minute video answer. So the first set of questions LG had was about the opposing side claims, people who are opposed to State Question 805. So the first question is, will this basically override the domestic abuse with prior pattern of physical abuse, and would it hurt future legislation because this is a constitutional amendment? Well, as to the constitutional part, this is, Constitution changes all the time for stuff. We've seen that over the past few years. There are processes. We're talking about Constitution. We're talking about Oklahoma's state constitution. There are processes, just like any legislative process, where you can amend, you can repeal, pull something out, you can propose new constitutional changes. It's never written in stone. It just requires that you follow the correct procedures to change. Now, as it relates to domestic with past pattern of physical abuse, that's actually a better charge for prosecutors to charge. This State Question 805 doesn't impact their ability to charge that at all. All 805 does is it reduces the ability of prosecutors to get enhanced up to life sentences on people. So past pattern of physical violence, there we go, on domestic abuse is located under Title 21, Section 644.1. And why I say it's a little bit better is for this reason. I'm getting ready to read who it defines as a family member for domestic abuse. So this can be a current or former spouse, a present spouse of a former spouse, parents, foster parent, child, person otherwise related by blood or marriage. That's the one I'm going to point out in a second. Person with whom defendant is in a dating relationship, individual with whom the defendant has a child, person who formerly lived in the same household as the defendant, a person living in the same household as defendant, a current intimate partner of a former intimate partner, or any combination of. So this is really the old definition of domestic abuse relationship. In 2019, November 1st, 2019, it changed. The new definition, as it relates to what a household member is much more limited. Currently, domestic violence, if it's charged as just a regular domestic violence, either a misdemeanor or a felony, can only be charged on parent if the victim is a parent, grandparent, step-parent, adoptive parent, or foster parent, children, including grandchildren, stepchildren, adopted children, and foster children. And here's the one that really catches: persons otherwise related by blood or marriage living in the same household. Now, that used to have an or instead of an and. That first set I read to you, that past pattern of domestic violence, that, as you heard, had an and in it. It says, or it had an or, sorry. Person otherwise related by blood or marriage, and then it stopped, and then person living in the same household. So now you have to have blood or marriage relation and live in the same household for domestic. So this past pattern is actually a better charge for prosecutors to charge against people if they're wanting to have a much more broad scope of who a victim in it is. Also, it carries 10 years, and the regular domestic assault and battery felony only carries 4 years. Now, the one thing that prosecutors do have to prove with this that they don't have to prove with a regular domestic is you have to show the past pattern of incidents have to be shown by a third-party witness or direct evidence. It can't just be he said, she said for this. But it does go up to a 10-year penalty on it. It is open to a much, much more broader range of people. And so this is a charge that carries a lot more teeth to it than the domestic assault and battery charge, regular domestic assault and battery charge. So no, it's still there. It can still be used. Prosecutors can still file it. Once again, 805 only impacts the punishment. So like domestic assault and battery, felony is going to be limited to a 4-year DOC sentence. This past pattern is limited to a 10-year. You're not going to be able to get life on one of these. So that kind of leads into the next question by LG, which was, whether this would shorten the length of sentences to a maximum of 3 years and eliminate the possibility of jail time altogether. No. So this misdemeanor or felony both carry imprisonment time, or incarceration time, I should say. The misdemeanor carries up to a year in the county jail. The felony, like I said, carries up to 4 years in DOC. I'm not sure where you got the 3 years. Domestic assault and battery by strangulation is a first offense felony, meaning that you don't have to have a prior domestic. If you commit a strangulation domestic violence, it's a felony on your first charge. That carries 3 years. So maybe that's where the confusion was. But the penalties for domestic violence are: first domestic violence offense, a misdemeanor, is up to a year. Second one is up to 3 years in prison. If it's strangulation, up to 4 years in prison. If it's strangulation, it's up to 3 years in prison. And if you can show the past pattern and meet all the requirements of that statute, it's up to 10 years in prison. What State Question 805 does is it doesn't allow those prison years to increase. So if you have prior convictions for other felonies, like the video I did on taking trees, if you have a prior a felony for illegally cutting timber, for not returning rental property, then your domestic violence charge doesn't get enhanced to 10 years or life sentence. So the final part in this opposing claims that LG talks about is statutory defined violent offenses are more difficult to prosecute. And that's a yes and a no. No, they're not more difficult just because they're a violent crime. It's just because violent crimes are sometimes the more intense type of crimes. They maybe require a little bit more proof. So, for example, it's kind of a common sense thing on that. I understand this is an opposition claim, but if someone has been charged with murder, then the prosecution and the state are going to have to do more to prove that than if they've been charged with a speeding ticket. It's the part of proving this isn't more difficult because it's a violent crime. It's just because what we list as violent crimes are usually the more serious offense, which require more investigation of. Sex offenses, for instance, those require a lot more investigation and to take it to a jury trial, it requires more proof of it to get a jury to convict than let's say a misdemeanor, shoplifting or something. You're going to have to lay more evidence on because you're asking for more time in prison. You're asking for a felony conviction, so you're not more difficult because they are or not on the violent crime list. It just depends on what the charge is. All crimes, you have to, one thing you tell a jury to explain this is it's like a cake. All crimes, you have elements that you have to put in, and at the end, if you've proven all of them, you get a conviction. Just like a cake, you put in all the proper ingredients in the right way. At the end, you get a cake. If I'm proving that it was willful, intentional and willful, unlawful physical contact with a person who is in a relationship or a household member, then I'm going to get a domestic conviction there. So it really goes back to whatever the charge is rather than the violent crime part. State Question 805 doesn't have anything to do with that. Prosecutors would still have the same burden on them to prove a murder under the statute, under the law as it is now, as they would under 805. They would still have to prove everything the same. The only difference is they wouldn't be able to ask for more time in prison than what the charge carries for a non-violent offense. So if they're trying to prove a non-violent offense like grand larceny, and they still have to prove everything the same as they would now. The only difference is when the jury goes to assign punishment, the jury doesn't get to go up to 10 years or life on it. They're bound by whatever the actual punishment is in the statute. So those are all the opposition claims. I'll do another video with the supporting claim questions you had, LG. But if you have questions about this, feel free to give us a call. Hit up our website, tahlequahattorney.com. Send us a web form if you find yourself needing legal representation and need some help with these type of issues. Thank you.